Hi everyone, it's Grant Abbott speaking, and welcome to our session on our new product, which is a bundled product. It's not as extensive or as big a monster as the Mode or our Super Mode, which will be coming down in May, but it's really simple, fast and efficient, and more importantly, it's really for the times at the moment. So given all the doom and gloom going around, people are actually going to start to get a wee bit depressed. Importantly, I think if we see it particularly overseas, and it's slowly starting to happen here, that everything's been brought to a standstill. It appears, at least in Australia, and I have to put take my hats off to the governments here, at least the federal government is working in coordination with all the state governments. And there might be a few tweaks in here and there, but they're all moving in the same direction. Unlike if you have a look in America, the governments there is you'll have someone like New York, which decides to lock everything down by the mayor. Then the governor, who are both the same political persuasion, say, no, we're not going to lock everything down because obviously that will cost them quite a bit of money and reputation. And then you've got the federal government as well. So it seems to be a bit of a diaspora over there. And then you've got poor old Italy, which seems to certainly have gone from bad to worse, and they're the sort of system that we don't really want to be involved with. But look, it looks as though we're slowly grinding to a halt. We haven't got like the car makers, etc., over in the US that are all grinding to a halt. But more and more people are working from home. This will be a good test of the NBN. I saw they're adding extra capacity, and for someone who's been working at home since 2002, I don't have a big drama about it, and probably will have a session over the next week or so on how to use Zoom, how I use Zoom, and how it actually makes quite a big difference for your clients, particularly if they're in lockdown, because they still want to see you. And you can virtually do everything over Zoom, including signing documents, recording, the whole box and dice. We're pretty lucky, though. You can see everyone's coming back to Australia. They go into isolation for a couple of weeks. And then likewise, a lot of people are leaving Australia to go back to their homes. But we're not so bad because we are an island nation. We've got some pretty big waters, which has helped in the past with illegal immigration, but we can sort of lock things down. And obviously the bug came in at some point in time from overseas and is sitting here. It hasn't had it's having a huge impact on the economy, obviously, but the number of cases and also the number of deaths are not significant. Now, that may well be the fact that we're not obviously treating, or we're only just getting test kits at the moment. But look, we will see a lockdown. My mother's nursing home in Adelaide, I can't go and visit her for the foreseeable future. Obviously, we've got telephone communications, but I'd rather her being safe and secure and certain than anywhere else. Luckily, we've got all her enduring powers of attorney and also her wills done. So we've sort of set it up, and the same with Dad. For Australia, look, I was talking to someone yesterday. It's probably not a bad idea, given that we're moving into flu season, for all those grey nomads to start to move up north ASAP, maybe even move inland where they can be isolated pretty well, and more importantly, it's nice and dry and warm up in northern Queensland. So I expect to see a great big population move up. It's not a bad idea. I mean, those people who can operate from home, we don't know how long this is going. It could be like 2 or 3 months. If you've got no ties, it's not a bad idea to lift up and then shoot up north. You're going to see that obviously there's a whole lot of good deals in terms of flights and also accommodation up there and Airbnb. So anyway, that's maybe the government should give us a grey nomad voucher. Who knows? But at the end of the day, this whole thing obviously brings to all of us that we're sort of pumping along for a long time. And it's funny, we're hearing for so long that climate change is going to kill us. And then bingo, out of the woodwork comes a virus. And this will change our lives, obviously, because we can never go back to what we had before. Obviously, there's always going to be a lot tighter borders now, and people coming in and out of the country. The idea that China is really in control of a lot of pharmaceuticals around the world, etc., will obviously change. And for those listening yesterday, as I said before, it's like a divorce, that we're all confused and shocked at the moment, but then that's going to turn very shortly if this doesn't resolve very quickly, which I don't think it will. It'll end up being grief and depression. And then once that happens, it is like a divorce. Then it ends up being anger, and the anger will be targeted towards probably I certainly know with the industry super funds will be targeted at those guys, and also be targeted at the Chinese. So we're in for some fun times over the next few weeks and months. But it's like anything; everything will pass. It's like the seasons. It's like the bushfires. I mean, you don't see any bushfires at the moment. They had their season. They came in, they ravaged, and much the same as this, and they came out. It'll be the same here at some point in time. There'll be a cure, or some will actually start to treat it with viral treatment, which I've seen is being done up in Queensland quite successfully. And then we'll see what happens from there. But, if they announce there was a cure tomorrow and, it was readily available in a month or so, then things would obviously have a huge change. But look, at this present point in time, unfortunately, people are going to be quarantined. They are in nursing homes. They are going to be in lockdown. And the key documents that really cover those sort of circumstances that people tend to leave, or more importantly, have done in the past, and they're pretty ugly. Some of the ones I've seen, particularly around the enduring powers of attorney, just don't really even operate in terms of self-managed superannuation funds. So, and also the will. Now, the problem is if you lose your competency, so this may well be, there's obviously, as I said, if you're going to go to grief and depression, that means a lot of anxiety. A lot of people may not be able to be work because of their anxiety levels, which I talked about yesterday. You'll be able to access money from your super, not your SGC amount, but anything else over and above that, by way of a temporary incapacity payment if you've got anxiety. But the main thing there is that who's then going to hold your enduring power of attorney? And the hard thing is, if you haven't got one, then it has to be a court-appointed one. And it's the same with a will, is that if you don't have a will and you die intestate, then again, it goes through the court process. Now, with all the courts shut down for the foreseeable future, it's just going to be a particularly ugly sort of situation. So I'm going to take us through a couple of things. So we have a look at the LYD Will and EPOA. So this is an easy to understand will, and also enduring power of attorney, which are basically put together. What we've got is a good client communication, which can be sent out as an email with a data capture attachment, or alternatively, given the urgency, it's not a bad idea to print these out, put them on your letterhead, and send them out by way of express post, which is only going to cost like about $3 or $4, but get it out to your clients. This is really an urgent and important issue. It's quick and easy to use on the LightYear Docs platform. So for both documents is only $198. But if you go through your system, if you're on an unlimited system, then obviously you can do as many as you want. Basically, accountants and financial planners, as we go through, you're going to see that a lot of the data capture, the stuff will be completed by the client themselves, and then you're just simply filling in the form. Alternatively, if you want to, we can organise with Tony and myself at Abbott-Family, and then we can go and set up for a small engagement fee. We can come and do a recorded teleconference or face-to-face, which may not be the case at this present point in time, given the current state of play of where we're going. So let me just bounce out of here and let's start going into what we've got, and then I'll build it. So what I've got here is, if you go into your LightYear Docs site, and I'll come back to this one a little bit later on, I'll go back to my home page. So if you come to the LightYear Docs site, I've just put something up on the support center. Now, if you're not registered on our site, it means you're not going to be able to see the support center. So all you have to do is you just have to register and then log in, and then you'll get all the access to everything in the support center. So that's important. And then you can jump on PAYG or alternatively do unlimited documents. So going on the support center, I've just gone in. You'll see there's webinars and training videos. One of the important ones, I'll come back a little bit later on. We've got, I'll have up here, you can see here document training videos on the March the 18th. The 7 legal strategies to access your SMSF. So that's if you haven't seen that one, that's absolutely a great one I did yesterday. In fact, I'm not going to say anything, but I did that yesterday, and guess what? The government's now come out and starting to talk about accessing super as hardship. And you'll see I've got a nice little, I wonder if I've got it up here. No, I don't think so. I've got a nice little a petition they're going to send out in the next week or two. Just wait and see how things go, whereby I'm recommending, or we're getting sign up for people who want to access their super. Unfortunately, with financial hardship, you have to be on Commonwealth support payments for 26 weeks before you can access support, and then it's a maximum of between $1,000, maximum of $10,000. But still, it's there, so it's not a bad one. So they're the webinar and training videos. This strategy webinar, you're going to see, this will be up shortly or later this afternoon. I'll be putting that up there. So if you haven't got it and you want to look at it again, it'll basically be up there. But what we're going to do now is, you'll see here the strategy info and advice toolkits. We're now starting to build this up quite a lot. I've got first off a Wills and EPOA retail pricing list. So I'll just click that up. You just have to click on, it's just a simple document there. You can go in and you can actually, if you want, I've already got it already up there, but you just download. And then if you wanted to send this out to your clients, or you can include it, these are typical costs that we charge if we came to your offices, if we are charging your clients, which, because you're doing the service, you'd be there. So if you've got an uncomplicated will, so that's a consultation from yourselves. So you could either do Abbott-Family, or you could just put your logo there. $7.95 for one, $11.50 for 2 mirror wills. You probably not, if you've got some, if you know that there's some pretty difficult circumstances, such as you know that clients are going to fight, or you've got children that are fighting, then you're going to go to wills with a testamentary trust. So that's a different ballgame. Let's leave that for another time. We're just simply trying to get the most of our clients up and running at the moment. During power of attorney, financial and personal, we've got there, and also SMSF. So that's $330. So you're probably looking at $330 and then $795. So let's just jump out of there and go back to our support centre. And again, anyone who's registered can access this, even if you're not using our system, which would be crazy if you're not, because it's really fits in. So you can see there's a client enduring power of attorney and data capture. I'll go through this, and you can see there's a whole lot of issues there, and talk about this basically being a key component for your clients. So make sure you have a look at the start of the document. Let me just blow this up a little bit later on. I can hear a plane landing here at Sunshine Coast Airport going overhead. I tell you what, it's been pretty quiet over the last few days, which is a bit of a worry. But anyway, so this is a client will and enduring power of attorney. So just to have a read through, it talks about obviously that if it's quite simple, has been signed off by Abbott-Family, particularly if you're facilitating the process for the client. But look, if you want to go through a legal sign-off through us, then you can book in for the client for both. And that's either a Zoom or whatever. But it's essentially up to you. But look, feel free to contact Tony, and you'll see there, tannermillis@abbotmorley.com.au. Just again, you can download this off the site. Now let's go into the letter itself. And I only did this this morning. So, must do, enduring powers of attorney and wills. The coronavirus is having an impact on society. Many of our clients, and so this is from us, from you to them. So you just put your logo up here and then shoot it out. Many of our clients, Australians, and for that matter, people across the globe, are concerned for their own safety and that of their family. We are asking ourselves a whole range of questions, including what happens if I or one of my family get the virus? We're all looking at that. Will it spiral out of control? We don't know. What about elderly members of the family over age 60 who seem to be more susceptible? So as I said, that obviously the government's looking at those that from Italy's dynamics. I don't know if it's changed because 495 people died yesterday there. But the average age of death or mortality over in Italy is 81. So obviously they live pretty long there. Now, we don't have the answers to these questions, but what we do know, so it's not no, that should be what we do know, and I'll change that, is that it's important, if not vital, to ensure while fit, competent and able that you safeguard your financial affairs by giving a spouse, relative or close associate your enduring power of attorney. This enables your EPOA to act on your behalf if you become sick, are quarantined for a long time, or become incapable of managing your financial or health affairs. In addition, your EPOA may be given the power to take your position as trustee of a self-managed super fund if your deed allows. Each state has its own EPO legal requirements, which we are on top of. Apart from an EPOA, it is also important to put in place a will or revisit your will if it has not been looked at in the last 2 years. The coronavirus shows us that change can happen quickly and we must prepare for change. A great safeguard at this very moment is put in place an enduring power of attorney and create or update your will and that of your closest loved ones. So many young families have neither document, relying on the courts to solve these issues. Yet the courts may be quarantined or closed. We've teamed up with lawyers and specialist estate planning advisors, Abbott and Morley, to provide an EPO and wills package in these challenging times. We've been suggesting it for clients when we do reviews, but now see the absolute importance of implementing it for all our clients and their families. The process is simple and quick if you get your EPOA and executors right. The person who you nominate as your EPOA can also be the executor of your will to ensure safety, certainty, security and continuity. It may be more than one, known as joint EPOAs and executors. The person or persons you choose will look after your financial, health and super affairs in the event of an illness or anxiety, should you so choose. In addition, they will be tasked as executor with looking after your estate upon your death, managing any of your specific gifts, such as property going to one or more family members, due to grandchildren, well, anything you desire. They can also limit any disposition of your estate to your lineage, which is your direct descendants or the bloodline only, which may include brothers and sisters in the event that a main or specific beneficiary is not alive. Important, build a line of EPOAs and executors. Abbott-Morley lawyers advise that you should provide a successor EPOA and executor in case, when the time comes, the person or person you appointed cannot or might not want to take up the role of you endowed upon them. And it does not hurt to have a second successor EPOA and executor. Safety, certainty, security are paramount. If something happens, we want to make sure your family are looked after quickly. Sorry, just having a sip of water. It's important to keep your electrolytes up, guys. As your advisor, we strongly recommend that together we undertake a fast and simple 3-step process to implement your EPOA and will. Complete the quick data capture attached, send to us as soon as possible so we can work with Abbott-Morley to draft your EPOA and will. We will get together and review the EPOA and will to ensure it is tax efficient and covers all the bases. If need be, depending on your family circumstances, we may need to have a meeting or teleconference with lawyers from Abbott-Morley to check the EPOA and will, plus witness the execution of the will. We are very busy at the moment, but our clients' EPOAs and wills are the top of our list of priorities. Along with Abbott-Morley, we can provide the above 3-step EPOA and will review service for, I'll put $1,050 or $1,700 per couple, which is a bit of a discount when we have a look at the pricing here. So send this out to the client. You can see if we put two together, so it's $1,150 and then two $550. So that works around about $1,700 there. But look, the pricing is in your ball court. So, choose as you see fit. Go up, higher or lower. Now, this is important, really important. If you would like your children and their spouses covered with EPOAs and wills, we have a special family offering. Just call us. Now, it's good to do mum and dad or grandma or grandpa. Why not bundle them all together? And look, I've done like 5 or 6 very easily under this system. So it's worthwhile bundling them all together and then effectively from that perspective, do a complete family set of EPOAs as well as their wills. At this point, we suggest that you complete the attached data capture. It won't take long when we get the process started. This can be emailed to us, email address or fax to us if you've still got it, or simply post it back to us. There is no time to waste, and the relief of getting these documents completed will take a lot of weight off your shoulders. So it's a little letter there. You know, I'm open to suggestions. Main thing there though is that we really need to stress the importance of getting this done straight away. Like if someone is stuck in a hospital for weeks on end, we need those EPOAs. If they suddenly pass away, then we need to have that will. So, and it's not only the older ones, it's the young ones. You're there for the family, but you should be able to do it quickly. Now we go in the data capture. As I said, you could easily, for those of you using, for example, Practice Ignition, or even if you're using MailChimp, and if you need be, I think we've got a webinar sitting in our site around how to use MailChimp with Ashley, or you can contact Ash at lightyeardocs.com.au. She can help you set up MailChimp. So you can actually send this out to all your clients as an email, or send it, as I said, as an express post letter. Importantly, from that perspective, if you're going to send it out as an email, then you'd have the attachment being the data capture, which they could send back. And obviously, if you're going to print it off, I would probably print it off and maybe do data captures for, I'd add probably 3 or 4 data captures just in case they want to do it for the children. Okay, so the data capture, EPOA and will. So let's go through. So who is to be your enduring power of attorney executor? You can see there I'm bringing the two together, and that's the best succession planning, because what we want to do is find someone who's mentally able and financially literate who can bring the two together. So this may be held jointly by one or more persons, so it could be a couple of kids or just a friend and one of the children. If you want different persons for the roles, write in the box the name of those persons, but for simplicity and safety, it's best to have one person or persons doing the same role. Now, in the event that none of your EPOAs or executives are able to fulfill their duties because of sickness, incapacity, or death, who is to be your second EPOA executor? This may be held jointly by one or more persons, so we put their names in there. And then we go down to the last ones as well, and we put all of that in there. So probably as well, I might actually update this one, because we need not only their names, but we also need their addresses as well, because that, what we're doing is we're going to get this data and then we're going to insert it straight into the EPOA and LYD will, which we'll see. Now, enduring powers of attorney. So we've got our succession of our executors and also EPOAs. So that's pretty good. Now, enduring powers of attorney, your EPOA will look after your personal financial, and if you have an SMSF, can act as trustee of the fund. You can give them unfettered control or provide limits, such as ensure that any healthcare is of highest standard, just to provide them with some guidance. If you'd like to put in some guidance, include what not to do, or guidance including what not to do, then insert in the blocks below, so they can write in there any T's and C's. Now we move down to wills, specific gifts before the rest of the estate, which is important. That's a feature that I really focus in on. Certainly for those of you who are coming to our virtual conference on the 23rd and 24th of March, we'll be going through and building a lot of the stuff for the clients. In fact, the first thing we're going to be spending on the first couple of hours is going to be asset protection. Anyway, after appointing a chain of executors to manage your estate, the next step is to guide your executor with your desire to make a specific gift to a spouse, child, grandchild, or other person. Once this is done and the gifts are made, anything left over forms the remaining estate, which may be passed in its entirety to a spouse or children individually or to be shared. Importantly, specific gifts rank higher in importance than the remaining estate, so spend time on specifics. The first step then is to look at specific gifts. Now, do you want to make any specific gifts to any person, such as my investment property at 5 Smith Street, Collingwood, should actually put there to go to my eldest daughter, Jane. So I had 2 people there, I'll change that. Or my sister, Joni Smith, is to receive $100,000. Or all of my estate is to go to my wife, Janelle. Or my executor is to distribute my personal effects and jewellery in a fair and reasonable manner. So it gives them a lot of suggestions for them to make their own will. It enables your data capture to be so much easier. Feel free to make as many bequests or gifts as you want. The more specific gifts you complete, it makes the role of executor that much easier and faster. So specific bequest, this provides your executor with your, so I'm going to have to change that to gift, with the authority to transfer property, shares, jewellery, cash, or a percentage of all of your assets after any specific bequest to a certain person or group of persons. Please be as specific as possible and identify the assets in persons, which may include a charity and does not have to be only persons or charities Western Australia. So we've got all the specific bequests. I'll go back and I'll just change this letter straight after this session. And so it'll be A-OK by the time we get to around about 11:30 my time. So I'll change this to specific gift rather than bequest because it sounds a bit dorky. So wills in the remaining estate. If there is any assets or monies left over after paying all expenses of the estate and also paying out all specific gifts, the remaining of the estate, calling the residual estate, is to pass to the main beneficiaries, and it should be if they are alive. Now, who are the main beneficiaries? And if more than one, are they to take equally or note down any specific percentages for any person? Now, if that could be, for example, the spouse gets 100% of the estate, or the spouse gets 50%, or this daughter gets this, so on and so forth. If the main beneficiaries are not alive, then who are the next in line to receiving the remaining estate? Now, if the second line of estate beneficiaries are alive, who's to get your estate then? And quite often that will end up being a charity for that perspective. Kim said, I've just signed up to LYD. Can you please direct me to where these documents? Absolutely, Kim. So let me just go back. As I said, I'm just going to give these a little tweak, like just a couple of things. And in fact, if you just signed up, Kim, what I would suggest you do is go through this process yourself, do your own LYD and EPOA, and then we're up and running. So let's just go back and you'll see here, I'll just close everything so you understand where things go. So what I'll do is if I just sign out of here, so I'm going to log out. You can see when I log out, all I'll get if I'm on the front page of LightYear Docs, I get home and product categories. Now, originally we had the support center up there, but we found a lot of people were just simply ripping off, and when people were talking about competitors who were simply ripping off a lot of our stuff. So what we do there is, Kim, good question. So I log in, this is my login details, and then that now makes me LY strategist. So I've now got unlimited documents. And you can see all my folders are basically sitting there. So these are all my client folders and test folders there. So what I do though is notice how the support center pops up. So with the support center, just to be wary, as I said before, every week I do a brand new video on this particular issue. So I've got EPOAs, I've got a whole lot of stuff there that you can see, but you can simply go in and have a look at that. Strategy info and advice toolkits. So the documents I just had a look there, you press there. And because it's dealing with estate planning, remember I had a look at the wills and EPOA retail price list. Simply click on that and you're going to get your standard pricing list, which you can simply send out to the clients. So you might send that out and then obviously give a discounted service. Now, the client enduring power of attorney and will letter with data capture, that is basically sitting there. So if I have a look, basically that is where you're going. This one, the sample asset protection, the protect the letter, we'll be getting at a different stage. This is a great one for those people who are coming on the virtual conference on Monday and Tuesday. So let's just jump out of there. This is a support center, so I'm going to have to go back to the site. So this is a separate sub-site. Now, I'm going to go to home. And I can do it different ways. I could do LYD Will, and then up will pop the LYD Will, or I might have EPOA. Okay, so EPOA and will automation. So that's in estate planning. Alternatively, if it's anything to do with estate planning, just go to estate planning, view the category, and you'll see up there the EPOA and will automation. So we've now got EPOAs for ACT, Queensland, WA, South Australia, New South Wales. I've also done one for Tasmania. If you're looking at doing, this last will and testament has got testamentary trust, so don't worry about that at this stage. The mode actually does everything, so don't focus on that at the moment, and there's your SMSF will. So let me go into the EPOA and automation. Have a look, you've got a whole lot of stuff there, talking about the product, some general information, the benefits. It's two important documents rolled into one, catering for life and death options. EPOA covers all states and based on local state forms. Both documents have been signed off. I don't have, it should be Abbott, so I can't even spell my own name. And then you've got FAQs. So if I go up and then I start the document, so I have to put it in a folder. This is really crucial. So what I'm going to do is I'm going to put it into Grant Test. You've seen me before, because that's blue, if I press start, I'm not going to get anywhere. I can only start when I've got green. The easiest way to do that, I use a separate folder, but if I simply go backspace, then you can see this comes up as grant test. See how I pressed the green? Now I can start. So this document is going to go into Grant's folder. Now for that, it's just generating in the system. So I need to name the document, because if I'm going to go back and relaunch, because what happens is you're going to get the data from the client, you're then going to proceed with this document, and then you're going to send it out in draft. Now when it comes back, you're going to make changes. So it's going to go into your folder, and so you need to give it a name. So I'm going to call it the Smith Family. It's all family Will and EPOA. So I just need that set. Now, for those of you, Kim, if you're on our system, particularly tomorrow, send in a high-res version of your logo, and then effectively for that one, what we'll do is you can simply put your logo in. Otherwise, you can use the Abbott-Family one. So Tim, with the actually, I'll get to the end, then I'll come back to those two questions you've got, Tim, around storage and also signing. So just leave that with me. So we're only doing 2 documents. We're going to do an EPOA. I'm going to do one for New South Wales, but you can see there we've got Tasmania, West Australia, ACT, and also the Northern Territory. So we're basically covering, and I will have to put up those separate EPOAs later on, but look, it's best to actually do both. So I'm going to do New South Wales. Now, is there a last will and testament? Yes, and you can see that now starts to bring up everything there. Now, the important one is we've got to do common parties. So these are the ones that are going to appear more than once in the document. So it's going to make your life so much easier. So essentially this is the data capture. So the first one is going to be the test data. So that's John Smith. Now I have to get John's address. We will be integrating, as I said before, with Xero Practice Manager probably in the next 4 or 5 months, and then Class Super. So if we go through there, Sydney, New South Wales, 2000. Now what I'll do is I'll then add his spouse. So I've then got his wife, Sally Smith, 5 Smith Street. Gosh, my typing's off today, sorry about that. I've been up since 3:30. Just been so busy trying to do all this stuff for you guys. Okay, 2000. Now, so that's the first one. Now I want to get into the executors. Now, the executors I've got back is his son, who also lives on Smith Street. Oops, yeah, Sydney, but in a different house, obviously. 2000, I'll go back, and I can always change this later on, as you'll see. It's not a bad idea as you go through, particularly this is quite long, is to save your answers on the way through. We have had a problem with a couple of people getting invalid sessions later on, and we found that it's a security certificate of Chrome. So, but it works really well on Firefox, this system, perfectly, which is strange. So then we've got another executor, and it's going to be his best mate, John Mengos, if you guys remember him. And he lives in 100 Castle Street, Fairlight, New South Wales, 2094. Now we're going to add his kids here. So we've got his 2 children, Matthew, and you're going to get this from, so whoever it pops up as a, Smith Street. Actually, I think, did I do Matthew? I've already done Matthew, sorry. So Marie, the daughter and the sister. So 200 Smith Street, Sydney, New South Wales, 2000. So you're going to pick this up. Whoever gets a specific gift needs to be in these common parties. So I'm going to add Matthew's children, Ben Smith. So 100 Smith Street, Sydney, New South Wales, 2000. And we've got another child there. So Ben's another grandchild of John. So this is William. Now, if they're not in the specific gifts, or as residual or what we call remaining beneficiaries, then you don't need to put them in. It's only if they actually poke their head up somewhere along the line in the data capture. So you'll see what I mean when I get down a little bit later on. So I've got everyone basically sitting in there. So that's A-OK at this stage. So I'm happy with that. I could add another if I want to. Now I can always come back. Now we don't have SMSF wills here. So if I did, I'd actually put a trustee, but that's more for the moat. So now what I'm going to do is slide into the enduring power of attorney. Now you're going to see what the benefit of having all these common parties are. Now we go to the principal. Now I could either type that in, but I know the principal is going to be John Smith. Now when I go down this track, I can obviously put in when the date is going to be signed, but at this stage, I'm not going to do that because I don't know when the client's going to come in. My preference just on the signing Tim for this, because these are pretty hardcore documents, I would effectively make sure that they are signed and witnessed in person. So even if it's someone who's in a nursing home or whatever, if they can come into your office or you can send it to them, get it signed, and I'd get 3 copies of these documents. I'll come back and look at that a little bit later on. But preference is for wet signature rather than digital. If you're using digital signature, you can easily package it up, send it off under digital sign. I think we use HoloSign, which is the best in the world, and flick it off to the clients and get it signed. Even I find with my PDF maker, I can easily get it signed if need be, and I'm using Nitro PDF. So I find that's an easy process as well. So for that, I've got the principal there. Again, digital is not preferred, but let's face it, if we're doing a will for someone and there's someone in Italy or there's lockdown, we may need to go at least digital signature. Okay, so who's the attorney? So I'm going to do an individual. I'm going to do, remember, the old John Mangos sits in there, but I'm going to do a joint. So I'm going to have John and also Matthew, the son, who are both the first line of attorneys. Now, how am I going to know that? Well, I'm going to know that because that would have come up in this data capture. Does that make sense? So I've got I'm working on EPOAs and executives. You can see this is easy. So I know who the first one is and I know who the second one is. So let's go back to the system. So I've got Matthew and John. Now the substitute attorney, what I'm going to do here is I'm going to make Sally, and I might also make joint there being Marie. Now, I'm not going to go for another one. I'm just going to stick to this one. But essentially, look, there's 4 people there. And what happens if one passes away, one's incapacitated, for example? If John's not alive, then it goes to Matthew, so on and so forth. Now, the power of attorney, this is for New South Wales, and each state will be quite different. So what we're doing is we're actually completing the relevant state-based EPOA form. And the reason we're doing that is then it fits in with not really providing legal advice around that. So if they're going to do for super, you need to click this button because most enduring powers of attorney have this one. Do anything on behalf of the principal can lawfully do by an attorney. And you'll see when you get into Queensland, Tim, you're actually going to have 2 separate documents, one for financial, one for health. But the financial one, when you're using our system, will also include the replacement trustee or director. My argument is that if this is not specifically included, then I would make a challenge that any such appointment doesn't cover the trustee of a superannuation fund if I'm just talking about personal financial, because your EPOA can't effectively appoint a person as a trustee or a director. So what we're doing here is putting our hand up specifically, and it's better to be specific than whatever. Now, given the state of the affairs of the world at the moment, I would go upon signing of the document. So they can actually jump in and be a replacement trustee or director straight away. They don't necessarily need to take financial matters, but I go upon signing the document. Do you want to revoke previous appointment of attorneys? Yes. Now, this is New South Wales only. Do you want Tony to be the person to certify the enduring power of attorney? I would go yes, because Tony is available. Now, if you go no and go to your local solicitor, guess what they're going to do? They're going to want to use their own enduring power of attorney. And once you start bringing this up, they're going to have no idea. They're going to have to do research. It's going to probably cost $1,100 anyway. So that's why most are fairly defective in that. The attorney should act jointly or jointly and severally. So probably I'd go, well, it depends on what you want to do. I'd go probably jointly. Does the principal want to terminate the appointment if one of the attorneys vacate office? I'd go no. So if, for example, John doesn't want to do it, John Mangos, then we put Matthew. So I go no. The substitute attorney should act jointly and severally. Now, the date to confer living and medical expenses, we don't know that. We sit down with a client. And you can also see, remember I had the powers or the things we don't want to do. So we could put in there, I want my attorney to ensure that I have 5-star health care. So that's pretty important. So that's as simple as you go. You can just do bullet points and do as many as you want. So I go to the next, and then from that, there's just a couple of questions. Let me do that. So Stephen Warner, can an EPOA be used for a single director trading company in case the director becomes incapacitated so that the attorney can act on company matters? So that's a really good question, Steve. So the EPOA that you've got here acts as financial matters. What you need to do, though, is effectively have in place a position whereby the person is automatically appointed. If the only director is the principal, then they can appoint the other person as director. You can't use an EPOA to appoint a director, and you can't use an EPOA to appoint as a trustee. You actually have to look at constituent documents. The beauty about the superannuation fund is, again, the key one under 17A 3B is that where normally we've got to remember have all members are directors or trustees. The exception is where we have an EPOA. So that's important. Karamjit, can we add Tony for Queensland as well? Tony's actually covered all across Australia. But you'll see, that's a really good question, the only state, if I go back here, the only state that requires a lawyer to sign off on and certify is in New South Wales. So if you're in Queensland, Karamjit, do your own will and EPOA. You'll go through that system and you'll actually find that you've got you're not going to have to go through that. So we're going through our last will and testament, which we've got there. So this is what I call a simple will. Is the SMSF will client fund? Is that because I only have a basic account? Okay, Kim, let me get back to you on that one around the toolkit. I'll have to go in and just change the settings. If you've just got a basic account, let me go in and change the settings and make sure that you get that. So I'm going to update the document. Also, I did it myself, and it's the first time I use that system. I'll go to our team and make sure it's up there. So thank you very much for that, Kim. So the date of the will, I don't know because I haven't got the client in ready for signing. So now here's the test data. Well, obviously, we're going to do it for John Smith. Now, if we're going to have a look at this, I'm going to put Tim Munro of, change GPS. So that is the advisor to the executor. So that's absolutely crucial. This is the one section that you really need to do. Now, the executor, remember, we know who the executors are. First line, it's going to be good old John Mangos. Relationship, best mate, or probably put best friend. Add another, and then we would have, remember, Matthew. So we've got that. Then we go to the successor, and remember, we follow exactly the same. So it's not that difficult. We've got Marie, and we've got then Sally. So we don't need to, I think we don't need to do any more. So then we go down to binding vote. So what we want to do is we've got John and Matthew. If it's a tied vote, who's going to come in? So I'm going to put Matthew and then I'm going to put Sally in that instance. So we'll go down the track. Now, the estate beneficiaries. So these are the ones, we just want to put down all the beneficiaries that are going to share. So We've got the spouse. Is she the main beneficiary? So after all the specific gifts, remember we go back to our fact find. Is she going to be the main beneficiary? We're going to yes. Now, she's not sharing it, so I'll go through anyway. So we've got Sally Smith. Now, I can add another, which I'll do. So I'm going to add a child, and I'm going to add here, I'm going to add Matthew. Is Matthew a main beneficiary? No. So Sally takes the residual, but if Sally's not alive or doesn't live more than 30 days, then goes down to the residual, which is going to be Matthew and Marie. Now, if Matthew's not alive, then I need to press a button to work out whether they've got, if they've got children, then it goes down to the children. And we know we've got Ben Smith and we've also got William Smith. So that's Matthew's kids there. So then we want to add another. So we've got, and this is pretty typical. So I've done enough of these now. So there's no beneficiary. I'm going to do main. Marie hasn't got any children. And so that's it. So I'm not going to have to add another at this stage. So I've got is there a specific gift? Now, when I go down here, is there a specific gift? Now, if I don't do anything more, I don't have any specific gifts, then everything is going to go to Sally. And then if Sally's not alive, it's split equally to Matthew and Marie. If Matthew's not alive, then it goes to Matthew's children. Now, is there a specific gift? Yes. Now, who's going to pay the expenses and taxes? Because what will happen is obviously that is going to be adjusted. I'll come, actually, Tina, I'll go through this one. So, Tina, that's a really good question. What's the difference between the LYD will and the last testament? The LYD will is the one we're looking at now. It has no testamentary trust in it. It's really simple, easy to use. If you jump over the complexity and you think you need testamentary trust, etc., then you'll use your last will and testament. That will be updated by, I would say, Wednesday next week. And it's actually going to be LYD will with testamentary trust. So that's sort of sitting there at the moment. So I probably wouldn't use that. Just focus in on this one at this present point in time, if that makes sense, Tina. So the first one was sort of a grab all. Now what we're doing is people come back to us and said, when we go along here is, well, we've got uncomplicated wills, which I'm doing now. That's the LYD will. The will with testamentary trust, which will be released next week, which is the LYD will, including testamentary trust, which is also the one that we've got at the moment, last will and testament. But thank you for that question. Anyway, going back, now I've been waffling around, so save your answers. So who's going to shoulder the expenses and the taxes? You could either do the estate or the beneficiary. So these are the little finagling that you're going to come around. A lot of this has tax issues, as we said, from it. So let's go to specific gifts. Is the specific gift to be shared by the executor amongst beneficiaries or gifted directly? So the first one we're going to go, well, it's going to be shared to it. So let's put my personal effects and jewellery. So if it is going to be shared, what will happen there is the executor takes the lot. Now, I add another and I go, no. So then I've got the whole detail. This is where I put all the common party in. So let's go in and we're actually going to give Sally, female, the family home at 5 Smith Street, Sydney, New South Wales, 2000. So instead of putting a residual estate, I prefer to put everything up as a gift, if that makes sense. It's just stronger. And particularly when it comes around to family provisions claims, it shows that the testators actually had a really good thought of things. So I do that. That's preference. Now, if you want to do a life interest, then you're better off using the other one, Tina, which is the last will and testament, which will now become the LYD and testamentary trust because that's got life interest in it. This is a very simple, plain will. So I've got to add another. What I'm going to do there is no, and I want to have Ben and also Willie. I'm going to have Ben, sorry. And he's going to have my collection of Marvel comics. Comics. I used to love those when I was a kid. He's male. Add another. And then we've got no. And we've got Marie, my Mustang convertible. Now, it's not going to be hard. I mean, you'd have like license plate bingo, if you guys know that. Anyway, so you can go through and build a whole lot of specific GIFs. And then we go down and then we end up going next. And that's essentially it. So you can see it's not a hard thing, but I've pulled a lot of that data straight out of the, I've put a lot of that data straight off the data capture I've got. So I download the document. I'll have a look at that. It comes out as in the PDF. Now I can do the last will and testament enduring power of attorney. So we go down there, we've got the EPOA, which we can have a look at. So we've got the enduring power of attorney there. So I, John Smith, blah, 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 and appoint John Mangos and Matthew Smith. I appoint more than one. I do not, we go through, act on my behalf as superannuation fund and personal financial matters. Each state will be quite different. As I said here, you can actually hear additional powers. You can delete or edit as required. So you can cross those out, but they're all pretty well, basic ones. So I'd probably complete them. Now here is where we need the, this is the attorney signing off here. And then section 19 of the powers of attorney requires Tony or your local lawyer to sign off, which you can put in. So either way, but again, this can be done. Again, this is just for New South Wales. Then you get the acceptance by the attorney, and then acceptance by the substitute attorneys. So that's Marie and Sally. And then there's a bit of a detail around that so the client can look at that. Then we go through the last will and testament. Again, it's produced by Abbott-Family. And I'll go through. So we've got, this was made by me, John Smith, revocation. You've got here, I hereby appoint my best friend, John Mangos and Matthew Smith, subject to their consent as my executor. John and Matthew predeceases me, so on and so forth. It goes to Sally and also Marie, but somebody has a binding vote. Again, if you're on an unlimited offer, then essentially just go and do it for yourself. Essentially, in fact, you might as well go and do it for all your family members. So you can see where the provision of advice here. Initial administration is just simply the executor, which along with the advice provider is going to bring all the money in, pay taxes, look after contributions, pay for funerals, so on and so forth. And then you've got the beneficiaries of the state, which is Sally, Matthew and his children, and then Marie. Now you can see here the specific gifts. Remember, I hereby provide to my executor to distribute on a fair and reasonable basis among my bloodline children, grandchildren, if there are any, my personal effects of jewellery. So that could be anything. If Sally Smith survives me by 30 days, she take full and complete interest in the following assets. If Ben Smith survives, he has to take a full and complete interest in the following assets. If Marie Smith, followed by, I made a mistake there because I put Ben in there. So we just need to go back and redress that one. So that's my Mustang convertible license. And any reasonable expenses, including duties, taxes, to be borne by the state. Now, if Sally Smith survives me by 30 days, my executor shall hold the remaining estate, including any super benefits paid to the estate for the benefit of Sally. If she does not, then it's got to be looked at in the rest of the clause of the will. Now, if it's superannuation death benefits that are going to the estate, you don't have to worry about the 30-day survivorship. Now, if my children, so if Sally's not alive, if my children, Marie and Matthew, noted above, survive me by 30 days, my executor shall hold the remaining estate, including any super benefits paid to the estate for the benefit of each proportionally. In the event that any of my children, Marie Smith, Matthew, is deceased or not capable of receiving benefits, and those benefits will be paid to their children. If there is no such children, my children, then to be split proportionally to my remaining surviving beneficiary. So it goes back to Marie. So again, this is just stock standard basic stuff. So I'll just go through there. That's basically here and signed and witnessed. As I said, I prefer to get wet signatures, but what I could do is I'll show you. I could save it into, for example, Smith. So this is into my Abbott-Morley advising, so I'll save it there. I can go up to my program here. And what I could do is open that platform. I'll just show you. This is really good. I love Nitro because you can actually go in and amend things if need be. So I'll go into Abbott-Family, and then what I'll do is I'll go into advising, and you'll see that here. I'll push that in there. And then what I can do from that one, you can see that I go to home. I can actually do quick sign myself or request a signature. So what happens is that then goes into the portal. So it says you're offline. It always does that anyway. So, oops. Okay, so it might be because I'm running. Okay, so I have to put my email in. But you put that in, and then I can just send it off to the client for a digital signature. But the preference would be to do 3 copies, one for the client to sign, and you've got to get all the attorneys to sign and keep, one to put in your vault, Tim, in your storage, and then you can send one down to Tony Animalis and put it into the Abbott-Family vault. Again, I prefer to have wet signatures for that, just in case something else comes up. What address should we enter if the main beneficiary lives overseas in Canada, in my client case? Look, that's a good question. I tell you what I'll do, Karamjeet, if you just leave it with me, because we did have someone who had some beneficiaries who are in India, so this does have an impact. What I'll do is we did tweak a couple of our programs to have an issue that if there was a client who lives overseas, then a separate address field will come up. So you'll just put it all in one address. So leave that with me. I'll go back to our team and fix that up. So that should be up and running by early this afternoon. So I'll just make sure my developer's up around. And so that's essentially it. It's a one-step process. It's a full-step process. Feel free to ask any questions while I'm here. The main thing is, look, for those of you who are on our unlimited program, and I can tell you I have seen the action coming through our portal, because what we do is we can't see your actual document numbers. We can see the numbers, but we can't actually go into them. But we can see lots of wills going up, lots of EPOAs, lots of moats, and also lots of protectors, which I'll be doing a session with Tim next week on. So this is really hot to trot. You know, I'd get it out to all the clients. You look as though you're doing the right thing. You're on top of things. And honestly, we've gone through, Tony and I, we did one for Madden Accountants, went through 4 of their clients. And once it's completed, there's a huge weight that is lifted off the shoulders of the client. So it's pretty crucial. So as I said, everything's moving rapidly, and I'm following from Tim. You know, we're seeing things changing so rapidly. The world we live in 2 weeks ago is no longer. It's going to be a bit of a shock for some of my children, for example, the millennials who really haven't seen hard times. We are going to go into a crunch, but it's not as if it's a full crunch for a long time. My fear is, though, that we are going to go from that stage of shock and confusion into grief and hopefully not depression. But the main thing is, for us, we've got to take a lead. I know Tim is really big on this one, and I'm sure, Tim, I think you've got another, if you're still online, just let me know you've got another session which would be in there. Okay, so can you please include a cover page in front of the will and EPO with specific signing instructions and storage? Okay, so sure, I'll do that. I'll put that into the front of the will as well. So that's a good question. I think Tim has got, is it possible to have legal sign-off letter with a will addressed to the client? Yeah, let me have a chat with Tony on that one. I think we're catching up with Tony anyway later on today, Tim. So let's go through that process. Anything to make it a lot better would be fantastic. If you did not see our 7 ways of accessing super, you can find it. We've got a virtual succession asset protection and estate planning conference on the 23rd and 24th of March. So if you'd like to come along to that, obviously don't come in person, but it'll be from 9 until 4 for 2 days. Look, if you're sitting at home, you've got nothing to do, it's all going to be recorded, and it's also good to get your CPD points up. Effectively, There's a special offer, $4.95 for those 2 days. If you'd like to do that, just jump onto I Love SMSF, and effectively you'll be able to do it from there. So anyway, without further ado, okay, so we've got Tim. His COVID-19 web event is next Monday, 1 p.m. at Melbourne time. Tim, if you could send me the link, and I'll send that out with the recording of this to everyone who attended today. From Karen G, my client wants to pass all his estate to his daughter and then future children. If she does not have children in the future, then the estate to go to his brother children. Can we put provision to transfer assets to someone who's not born yet? So yeah, that's the case. So Karen G, if you go back and look at this video again, that's exactly what I did in this situation. Remember, we could, for example, we've got the main beneficiary, and if the main beneficiary is not alive, it can go down to then their children, and we can then just put in their children, but we can put in their children yet to be born, but a bloodline. So if need be, I can show you a little bit more around that if you want to come back to me early this afternoon. Once I fix all that, we can take it from there. Anyway, look, it's prime time. Thank you very much for all of your time. It's really busy. Tomorrow at 12:30 Australian Eastern Daylight Savings Time, we're looking at investment strategies again, which is not too bad, but it will be a really good session, and I'll show you how to make sure that all your investment strategies comply with the new guidelines, because I can tell you 98% of them out in Australia do not at this present point in time. Anyway, it's Grant Abbott signing off.